The emergence of human rights law in the international sphere is one of the most significant developments since the end of the Second World War. The second half of the 20th century saw the adoption of several international human rights instruments, which include specific treaties dealing with the prohibition of racial discrimination. The same spirit is reflected in Article 1 of the United Nations Universal Declaration of Human Rights, known as UDHR. UDHR is significant as it upholds, I quote, "All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in spirit of brotherhood." Unquote. In 1948, the United Nations General Assembly declared the equality of all human beings. The principles of equality and non-discrimination represent the twin pillars upon which the whole edifice of modern international law of human rights is established. It was with this perspective in mind that the members of UN had collectively pledged themselves to take joint and separate actions on prohibiting discriminations based on race. In run-up to fulfill the common quest, a draft proposal to ensure equality and non-discrimination against any racial incitement and discrimination was adopted and subsequently opened for signature and ratification as per the General Assembly Resolution 2106 Clause 20 of 21st December 1965. The International Convention on the Elimination of All Forms of Racial Discrimination, popularly known as CED, formally came into force on 4th January 1969. Racism can be argued to have become a part of world's politics with the expansion of European market and subsequent colonization. The new people that the Europeans came across during the exploration were subdued and began to invent the new theories about their identity and race. For example, the colonization of black Africans and Asians were propelled by the self-acclaimed racial superiority of the Europeans for being a white race. The whites began to produce self-acclaimed cultural and civilization supremacy over the rest of the world. The rest therefore became the other, who is incompatible for self-rule and freedom, according to the yardsticks set by the Europeans. As a result, the 19th century science in Europe heralded differences of races, and it largely helped the Europe's imperial ambitions. Such a hegemonic European conception began to be challenged with the growing anti-colonial struggles all over the world. With the conclusion of the Second World War, the right to equality, non-discrimination, and freedom for everyone became integral to international discourses on human rights. Responding to the strong anti-Semitism incidents in Europe, the UN General Assembly was compelled to adopt a resolution condemning such a widely existing discrimination in December 1960. In 1961, the Economic and Social Council also acted upon bringing a common consensus on eradicating racism. The proactive role of UN in this regard generated a good environment for enacting an international legal system on anti-racism. As a result, throughout the 1960s, the Africans and Asians mainly began to raise the issue of eradicating racial discrimination in the world. Therefore, the idea of equality and non-discrimination subsequently came to be included in various initiatives and conventions of the UN. The International Covenant on Civil and Political Rights, 1966, International Covenant on Economic, Social and Cultural Rights 1966, Convention on Elimination of All Forms of Discrimination Against Women 1979, and Convention on the Rights of the Child 1989 have all incorporated the principles of equality of all, irrespective of race and culture. Materialization of CERD in 1969 can be seen as a part of the above-cited international conventions. As of April 2013, CERD has 87 signatories and 177 parties. Let us now try to understand racism. To define racism, racism refers to beliefs, structures and practices that negatively discriminate against people based on their perceived or ascribed race. Racism is also used to describe the belief that race is the primary determinant of human rationality. This school of thought even aspires to treat individuals differently based on the specificity of a race and originality. Put simply, racism originates from differentiation based on color, reason, religion, and culture, etc. Let us now examine CERD, how it sets a legal standard for the world to follow. CERD of 1969 is an appropriate example in the annals of the UN's initiatives against racism. CERD consists of several legal norms and guidelines with regard to the protection of human rights and anti-racial laws, which are incumbent upon the signatories, while entrusting a moral obligation on all the states in the world. Setting its legal standard, Article 1, Clause 1, Part 1 of CERD says, I quote, "In this convention, the term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life." Unquote. Article 1, Clause 2, Part 1 further adds, I quote, "The Convention shall not apply to distinctions, exclusions, restrictions, or preferences made by a state party to this convention between citizens and non-citizens." Unquote. Article 2, Clause D also provides important guidelines to the signatories of CERD as it says, I quote, "Each state party shall prohibit and bring to an end by all appropriate means, including legislation as required by circumstances, racial discrimination by any persons, group, or organization." Unquote. On the other hand, Article 4, Clause C puts additional responsibility on the part of the public authorities or institutions to disallow any sort of racial discrimination. Article 5 of CERD can be said to provide an overview of the CERD legal parameters on restraining racism. The Article 5 consists of the following objectives: equality of everyone, no discrimination on the grounds of race, color, or ethnicity, right to security of persons, and protection by the state against violence, right to freedom of movement within the border of a state, right to leave any country, including one's own, and to return to one's country, and finally, right to nationality. In brief, from Article 1 to 7 of the Part 1 of CERT deals with the responsibilities of member states. We will now discuss about the Committee on the Elimination of Racial Discrimination. The Article 8, Clause 1 of the Part 2 of CERT consists of the provision to establish a committee on the elimination of racial discrimination. The committee comprises of 18 experts of good working experience and acknowledged impartiality elected by state parties. The Article 8 Clause 2 further adds that the members of the committee shall be elected through a secret ballot from a list of persons nominated by the state parties. It can be argued that the CERT is monitored by the Committee on the Elimination of Racial Discrimination, also called as committee. The committee is a body of independent experts that monitors implementation of CERT principles. All state parties are obliged to submit regular reports to the committee on how their rights are being implemented. States must report initially 1 year after acceding to the convention. The committee examines each report and addresses its concerns and recommendations to the state party in the form of what they call concluding observations. In addition to the reporting procedure, the convention establishes 3 other mechanisms through which the committee performs its monitoring functions, which include the following: early warning procedure, examination of interstate complaints, and examination of individual complaints. The committee also publishes its interpretation of the content of human rights provisions known as general recommendations or general comments on thematic issues and organizes thematic discussions. Similarly, the Part 3 of CERT, which comprises of several articles from 17 to 25, engages with the issues of ratification, actualization of the ratifications, and lay down norms and ways of effecting an amendment. We will now examine India, CERT, and the context of racism. India acceded to CERT on 3rd December 1968. It is highly common to find a member state not acknowledging the existence of racism in their own countries, no matter even if it is a ground reality. The case of India is not an exception. The question of racism covers a wide range of socio-political realities as experienced by several communities and citizens. In case of India, issues of racist discrimination have rather come from the experiences of the hitherto excluded communities, including the scheduled caste and scheduled tribes. On the other hand, the experiences of the people from the northeast India have been that of alienation and racial anxiety. In this environment of politics, people from the region are put under strong surveillance and are suspected lot, thereby making them potentially vulnerable to harassments and attacks. Taking cue from the CERT guidelines, there is a growing demand for enacting an anti-racism law in India. For example, according to the CERT Article 2 Clause 1d, there is a need to enact a state legislation on anti-racism. If the ongoing demand for having anti-racism law in India as put forth by the civil society groups from the northeast India is accepted, the anxiety and insecurity that confronts the people from the region can be expected to be addressed to some reasonable extent. It is important to examine the critical and weak areas of CERT. Several legal procedures of CERT are considered to be weak and problematic. To start with, the problematic aspects of CERT legal provision can be discussed with reference to Article 1, Clause 2. Article 1, Clause 2 is unable to guide the member states on how to deal with the issues concerning the rights of citizens and non-citizens. Article 1, Clause 2 is considered ambiguous about whether non-citizens are included within the scope of the Convention and the extent to which non-citizens are protected. The article is dichotomous, as it has been pointed out that the article does not require equality between citizens and non-citizens, but clearly permits their differential treatment. Similarly, Article 1, Clause 3 consists of legal contradictions as it suffers from crucial limitations. It allows the member states to promulgate laws to deal with the issues of nationality, citizenship, or naturalization. However, CERT strictly adheres to restrict racism as it says that laws and provisions do not discriminate against any particular nationality. Despite all the legal and juridical complications, it would be of great advancement in the field of fighting against racism if the member states adheres to the core philosophy and guidelines of CERT. Towards the conclusion, we can argue that the United Nations has been playing an important role in dealing with the questions of racism all over the world, and its strategies and policies for dealing with the promotion and protection of human rights in general has been extensive. Racial discrimination is a global problem that manifests itself in a variety of ways. The international standards adopted and proclaimed by the United Nations are applicable to all and not only with respect to a pre-selected number of countries and situations. Now the time has come to recognize and to accept that the international standards as adopted and proclaimed by UN are applicable to one and all. It would be very appropriate to remember what Martin Luther King Jr. once claimed when he said, "I have a dream. Today, this dream is about equality, non-discrimination, and a world free from racism."